Welcome back. Another interesting piece of this story and the history of this kind of deference, Alicia, is the way that it has been extended by other cases and doctrines, some of which the Supreme Court has now pared back. One of them that was flagged by now Justice Neil Gorsuch, who has been a deference hawk for a long time, when he was a judge on an appeals court, is called Brand X deference. And this was a case in which there was a court that had interpreted a law, I believe. This is what that law means, the court had said. And then after that, there was an administrative agency that had a different interpretation, and that different interpretation was then upheld by the courts, essentially overruling what the courts had previously said the law meant, which seems to get the constitutional structure exactly backward. There's another one called Our Deference, which involved agencies interpreting ambiguities in the agency's own regulations. And Alicia, part of why I think that's interesting is that there were conservative judges and justices, including the late Justice Antonin Scalia, who began their judicial careers as defenders of this kind of deference, and as time went along, became more and more skeptical of it. So Justice Gorsuch has told a story that he has heard from Justice Thomas, that the two of them were having some conversation, and this Our Deference came up, and Scalia said, "Who wrote that terrible opinion?" And then Justice Thomas said, "Well, you did, Justice Scalia." And Alicia, I think that is a fascinating part of this story and explains how we've gotten to this point 40 years after Chevron.
Right. The reason, or one of the impetuses for the Chevron doctrine, we discussed earlier that it was to some extent accidental, but it arose in part because a lot of judges were actually overruling agencies willy-nilly in their interpretations, and how it was actually substituting their policy preferences for those of the elected branch. And so they were actually in some ways making law. And I think this frustration also animated Justice Scalia. As you mentioned, he wrote the Our precedent that judges must defer to regulators' own interpretations of their own regulations. Now, the Supreme Court essentially preserved our deference a couple years ago in a case known as Keyser that involved veterans benefits, with the chief siding with the liberals, in that they kind of narrowed it and provided a bunch of steps that judges must go through before actually paying deference to the regulators. And I think where the Solicitor General was going in today's arguments is that, well, if you think Chevron is wrong, maybe just narrow it and do what you did a couple years ago in this Keyser v. Wilkie decision, but don't throw out the baby with the bathwater, right? And that was kind of the gist of the Solicitor General's arguments today. But I think there's broader issues that the Chevron is just proving unworkable. And this is important when the courts or justices decide whether to overturn a precedent, is the workability of it. And here it just has created a lot of confusion with precedents. I think, as you may have mentioned, agencies are overturning each other's regulations every 4 years. The court's decision upholding a regulation will then be reversed by a new agency. And you're seeing this, I mean, you see it a lot in the EPA context with the EPA regulations, is that actually what happened, interestingly, with going back to West Virginia v. EPA, and that involved the Obama Clean Power Rule. And if you recall, they basically used, invoked the Clean Air Act to force kind of a generation shift in the power mix to renewables. Now, that was challenged and then actually it stayed by the U.S. Supreme Court in 2015. Now, the Trump administration came in and said, well, we're actually going to scrap that rule and redo it. And then the DCs, then the liberal states actually sued the Trump administration for saying and doing that. And the DC circuit basically stopped that and revived the Obama Clean Power Plan. And this just shows, as I said, I think this example actually really underlines the unworkability of Chevron. And ultimately, the Supreme Court came in when the coal plants and others in states like West Virginia then challenged the DC circuit in in that case. The Supreme Court ultimately decided under its major questions doctrine, basically struck down the DC circuit decision and the Obama Clean Power Plan. But how long did that take, and how much confusion and uncertainty was there for businesses in the interim? I mean, this is what basically happens under Chevron. And I think that that's probably one of the more, I think, compelling arguments that the plaintiffs are making making on the stare decisis point, that actually Chevron creates uncertainty and creates these policy swings. And it doesn't, unlike her, as opposed to what the Solicitor General argues, that Chevron creates kind of a platform that ensures policy consistency when Chevron, in fact, does just the opposite.
I'm hearing some criticism of this decision as if it is all about policy outcomes. And the theory is that Republicans in the 80s were in charge of these administrative agencies under President Reagan, and there were all sorts of liberal judges that were overruling them. And so in that context, Republicans wanted deference. Now we have a Democratic administration, and we have a federal bench with many conservative textual judges on it. And so now Republicans don't want deference. And I don't think that argument is quite right. I mean, some of it, I think, has to do with who is the aggressor, who is really sticking to the law and who is not, and that may have changed. It may be that judges were more willy-nilly overruling agencies in the 80s, and now we have a judiciary that is much more textualist and is focused on the actual law. And so the balance of whether that kind of deference is appropriate may have changed. But also, I think some of it is just 40 years later, we've gone down this road and gotten to a point where we're looking around and we have administrative agencies that are interpreting these broad statutes in ways that are pretty akin to making the law. And it seems to me that it's an appropriate time to take a closer look at whether that really fits with the constitutional structure, which doesn't mean that Congress can't delegate anything to executive agencies, but it has to do so in ways that are clear and give guidance and don't let the administrative agencies essentially run the show.
Yeah, I couldn't agree more. The left is obviously trying to make this sound as this is another attempt by the Supreme Court to impose policy outcomes. No, we have been suffering under this growing problem. It was, as we noted, probably a bit accidental. And so we've now reached this moment in which classic use of the word ripe. This is an issue that is ripe for revisiting, especially because, to go back to the accidental point, a couple of the really strong legal arguments that have been made in the course of this case is that in fumbling down this road as well 40 years ago, the court actually offended some bedrock legal principles, including, for instance, the Administrative Procedure Act, which was passed well before Congress came up with the Chevron Deference. And that law specifically requires, quote, a reviewing court shall decide all relevant questions of law. I think there's some questions about the due process clause and simply the fact that there's no constitutional basis for Chevron. Again, as noted, show me the piece of the Constitution that says that a class of so-called bureaucratic experts have certain rights and privileges. It simply doesn't exist. And it's notable, too, that this is also a classic case of the court sometimes not dealing with the question for so long because it doesn't want to have to grasp the nettle. And if you look, as Alicia noted, this question of the hour precedent came up back in 2019, that John Roberts joined with the liberals on kind of hokey basis to come up with a reason to generally preserve it. There was a grousing from the dissenting judges at the time. You've also seen the court, I think, attempt to dodge things a little bit by turning to the major questions doctrine as a way of ignoring Chevron, saying, well, if something is a regulation is that big and that egregious, then clearly Congress did not envision it, so we can strike it down on that point. But as was made in arguments today, the plaintiffs pointed out, why should only very large regulations be subject to that kind of scrutiny? There might be smaller ones that are very, very consequential to the parties involved. And just because they aren't, quote, major doesn't mean that you should just say, well, in that case, government always wins and the regulators always win. So I'm actually really hopeful that they do grasp this big decision and that they don't just go down the road of narrowing this, because there's a lot of pressure on the court. As Alicia was noting, the Solicitor General was saying, well, don't throw it all out. But if you're going to fix it, fix it. And a narrow decision in which you said, well, the law really needs to truly be ambiguous before you give regulators deference. And you have to use every tool to make sure that you've discovered that it was ambiguous. That's just going to leave the same sort of mess and give lots of courts the continued ability to jump out and say that we're just giving regulators full say.